The robe wasn't the evidence. 3 HOA lawyers came to my farm expecting paperwork, pressure, and the threat of court to make me surrender a road across land my family had owned for generations. They thought I was just another farmer in muddy boots. Then they walked into a courtroom and saw me wearing a black robe. But that was not the moment they lost. They had started losing weeks earlier, when they decided confidence could replace a deed. "You gentlemen sure you want your names attached to this?" That was the first thing I asked when 3 black SUVs stopped across the entrance to Whitaker Farm at 7:12 on a Thursday morning. My tractor was idling beside the lower field. Fresh-cut hay lay in clean rows. Diesel hung in the cool air, and the hydraulic pump on the baler clicked every few seconds behind me. Patricia Holloway stepped out of the first SUV. She had been president of Stonegate Ridge HOA for 4 years, long enough to start speaking about the subdivision as if she personally owned every roof, sidewalk, drainage ditch, and view beyond it. She wore cream slacks, a navy blazer, and expensive shoes that sank half an inch into the gravel. 3 attorneys followed her. Richard Sloan, lead counsel. Kevin Barrett, real estate specialist. Andrew Pike, the youngest of the 3, carrying a leather folder thick enough to make the meeting look official before anyone said a word. Patricia gave me the smile people use when they believe the decision has already been made. "Daniel, we need to resolve this today. My tractor says otherwise." Richard opened the folder on the hood of my pickup. "We represent Stonegate Ridge regarding its established access rights across the eastern portion of your property." "Established where?" He paused. "In the supporting property documents." "Recorded where?" Kevin stepped forward. "Mr. Whitaker, this involves several interconnected instruments." "That wasn't my question." Patricia folded her arms. "This is exactly why we brought attorneys." I nodded toward the 3 of them. "Good. One of them can show me the grant." Nobody did. Richard unfolded a survey exhibit across my hood. A yellow line ran directly through my eastern pasture. Not along the edge. Through it. The proposed corridor crossed a drainage swale, passed within sight of my equipment shed, and continued toward the county road along ground my grandfather had fenced decades before Stonegate Ridge existed. Stonegate intends to formalize this corridor for emergency access, utilities, drainage, and future community connectivity, Richard said. "We're offering you an opportunity to cooperate before litigation becomes necessary." He slid an agreement toward me. Temporary access agreement. That was what the first page called it. I read the second page. Then the third. On page 4, buried inside language about temporary access, was an acknowledgement that Stonegate already possessed a pre-existing right across the corridor. I looked at the exhibit again, then at the parcel number printed beneath it. Wrong. Not wildly wrong. Just wrong enough to matter. I glanced at Andrew. He noticed me noticing it. That interested me. Patricia tapped the signature line. "Sign today, and we can all move on." "What happens if I don't?" Richard closed the folder halfway. "Then this stops being a negotiation." On the passenger seat of my truck was a brown envelope from the state courthouse. Only one corner showed beneath my canvas jacket. I checked my watch. Richard mistook the gesture for nerves. "You have somewhere to be. Tomorrow morning." Patricia sighed. "This is more important than whatever appointment you have." "I have court." Kevin gave a faint smile. "Then perhaps you already understand how expensive legal disputes become. Better than you think." Patricia pushed the pen closer. "Sign it, Daniel." I picked up the agreement. Not the pen. I folded the pages, handed them back to Richard, and said, "No." His expression hardened. "You're making a serious mistake." "Maybe somebody is." I climbed into the truck. Patricia called after me. "We'll file if we have to." I started the engine. "Then make sure everything you file is accurate." 3 lawyers stood beside my gate while I drove toward the barn. They thought they had brought enough law to frighten a farmer. What they didn't know was that at 9 o'clock the next morning, I would not be standing in front of a judge. I would be sitting behind the bench. But my job had nothing to do with whether Stonegate owned a road across my farm. That distinction would become very important. Whitaker Farm had been in my family since 1948. 206 acres. Pasture, hay fields, 3 wells, a creek, a red equipment barn, and a property line my father used to say he could walk in darkness. Stonegate Ridge arrived much later on the hill east of us. At first, it was 64 homes. Then came the pool, clubhouse, tennis courts, decorative entrance walls, and streets named after trees that had been removed to build them. 18 months before the SUVs appeared, Patricia had visited me alone. No lawyers, no folders, just sunglasses, perfume, and an offer. We'd like to purchase a narrow access corridor, she said. For what? Future improvements. Meaning? She hesitated. Potential expansion. I told her the land was not for sale. 2 months later, she came back with more money. Then more. I refused all 3 offers. After that, the vocabulary changed. Their letters stopped saying purchase. They started saying access, then historical access, then established access. Finally, existing easement rights. Funny how quickly land you refuse to sell becomes land someone insists they already have the right to use. That Thursday afternoon, my daughter Madeline found me in the workshop. She managed most of the day-to-day farm operations now and had inherited her grandfather's ability to detect trouble by counting unfamiliar vehicles near the gate. 3 lawyers. 3. That seems excessive. Depends how weak the argument is. She leaned against the workbench. You going to tell them? Tell them what? She gave me a look. I smiled. Not relevant yet. Behind us stood my father's old steel cabinet. The lock stuck unless you lifted the door while turning the key. Inside were deeds, tax records, water agreements, photographs, old correspondence, and surveys going back farther than most people would ever bother keeping. Dad believed paper became more valuable the longer other people assumed nobody had saved it. I pulled out the 1979 boundary survey. Near the eastern line, Dad had drawn a pencil circle around 2 words. Iron pin. Madeline and I walked outside. At the fence corner, I pushed aside grass with my boot. The rusted cap was still there. Exactly where Dad's survey said it would be. Still there, Madeline said. Boundaries usually are. Back in the truck, I compared the old survey with Stonegate's exhibit. Their proposed yellow corridor definitely crossed our land. But the parcel number beneath the map did not match the eastern strip. It pointed toward an older agricultural tract farther north. That alone did not prove misconduct. Clerical errors happen. Survey exhibits get mislabeled. Good evidence starts by resisting the temptation to call every inconsistency a conspiracy. So I did what I had trained myself to do for years. I preserved the record. Every letter, every attachment, every email, every envelope, every version of the map, every photograph of the field and the boundary markers. That evening, Stonegate's attorneys emailed a 14-page final opportunity to resolve the dispute without litigation. Same yellow corridor. Same parcel number. Same problem. Madeline looked at the courthouse envelope on the passenger seat. You left that where they could see it? I left my mail in my truck. And you told them you had court. I do. She laughed. Richard probably thinks you're being sued. Then Richard should avoid assumptions. 2 days later, the attorneys returned. Patricia came with them. This time they met me beside the eastern fence. Richard looked at my questions, my notes, the old survey tucked beneath my arm, and finally said what he had apparently been thinking since the first meeting. You keep asking questions like you think you're one of us. One of who? People who understand property law. Andrew looked away. Patricia did not. Kevin spread another exhibit across the hood of Richard's SUV. Our position is that Stonegate possesses enforceable access rights based on prior use and recorded property interests. Recorded under which instrument? Richard gave me a document number. I wrote it down. Which parcel? Kevin answered. I wrote that down too. Who certified this exhibit? Silence. Patricia stepped closer. Why does that matter? Because your yellow line crosses my field. We've established that. No. You've colored it yellow. Andrew almost smiled. Richard didn't. He pulled out another agreement. Sign this, and Stonegate will defer further legal action while the permanent access issue is resolved. I read it carefully. Same buried acknowledgement. Signing would not merely allow temporary entry. It would help Stonegate claim that I had recognized a pre-existing access right. I closed the document. No. Richard lowered his voice. Refusing reasonable accommodation can become relevant later. So can asking someone to acknowledge a right you haven't proved. For the first time, the mood changed. Andrew looked at me differently. Not like a farmer who was being stubborn. Like a fact pattern he had not fully understood. Patricia laughed once. You really believe you know this better than 3 attorneys? I believe numbers don't become correct because 3 attorneys repeat them. Nobody answered. That afternoon, I called Laura Bennett. Laura had handled my family's private property matters for years. She was the kind of lawyer who became quieter when other people became louder. I sent her every document Stonegate had provided. 20 minutes later, she called. Dan, that tone sounds useful. Where did they get this parcel number? That's what I'd like to know. It ties to an old recorded access instrument. For my eastern field? No. I sat forward. Where? Farm Service Lane farther north. Almost half a mile away. So an easement exists. Something exists. Different legal description. Different location. Different purpose. I looked toward Dad's steel cabinet. Then we verified before saying anything stronger. Exactly. The next morning Laura came to the farm. We spent hours at the workshop table comparing deeds, plats, surveys, and Stonegate submissions. Rain tapped against the metal roof. Madeline sorted records by year. Laura placed the old service lane instrument beside Stonegate's yellow corridor. 2 different locations. 2 different descriptions. One recorded right. One proposed road. Then she stopped. Dan. I looked up. Her expression had changed. What? She turned a document toward me. That signature doesn't belong there. At the bottom of an affidavit was a name written above a notary block. Daniel R. Whitaker. It looked like my signature. Close enough that someone glancing at it might believe it. But I had never signed the affidavit. And my middle initial was not R. Laura tapped the page. This statement says the Whitaker family previously acknowledged access across the corridor. I never signed that. I assumed not. Madeline came around the table. Where did they get it? We don't know, Laura said. And we're not going to guess. She slid the affidavit into a clear evidence sleeve. From this point forward, originals stay untouched. Digital copies get preserved. We build provenance before we use adjectives. I nodded. Don't interrupt people while they're creating a record. Laura gave me a thin smile. Exactly. The affidavit changed the character of the dispute. A bad parcel number could be careless. An aggressive easement theory could be wrong. But a document carrying a signature I had not placed there required a different kind of attention. That did not mean we knew who created it. We didn't. That mattered. Good lawyers do not outrun evidence. Good judges shouldn't either. Laura hired an independent surveyor. He found Dad's iron pin first, then a second recorded monument farther south. His measurements aligned with the old survey. Stonegate's proposed road crossed Whitaker Farm, not the historic service lane, not a disputed sliver between parcels. My land. While the surveyor was working, Patricia's Mercedes stopped at the gate. She got out, but did not cross the fence. What are you doing? Measuring. You were already provided a survey. Laura answered before I could. We're obtaining independent verification. Patricia's eyes moved from the survey equipment to the fluorescent markers, then to me. This intimidation is unnecessary. I almost laughed. She had brought 3 lawyers to my tractor, and somehow a survey instrument was intimidation. Laura handed her a business card. All future communications regarding the property dispute go through me. Patricia took it between 2 fingers. You think hiring counsel changes Stonegate's rights? No, Laura said. Records determine those. That evening, Laura sent preservation notices to Stonegate, its attorneys, the survey consultant, and the entities involved in the proposed corridor. Emails, draft exhibits, board minutes, survey instructions, title opinions, original electronic files. Nothing was to disappear. 2 days later, I heard an engine along the eastern field. A contractor's pickup was crawling beside the fence while 2 workers placed orange stakes every 50 feet, straight across my pasture. Madeline came out of the barn. They're marking the road. I see it. I'm pulling them out. No. Dad. Leave, everyone. I took out my phone. Photograph. Time. Location. Another stake. Another photograph. The workers finally noticed us. One raised both hands. We were told this was approved access. Who told you? Stonegate Project Office. Keep your work order. He frowned. Why? Because you may need it. He was not my enemy. He was a contractor doing a job based on information someone else had supplied. That distinction mattered too. By noon, Laura had formally disputed any right of entry across the eastern field and demanded that no construction begin until the title questions were resolved. She attached the independent survey. She did not attach everything else. Not yet. Richard called me that afternoon. You're making this much more expensive than it needs to be. For somebody. We have a documented access interest. You have a documented interest somewhere. Your attorney is playing games. Then call her. I'm calling you as a courtesy. No, Richard. You're calling because Laura asked for the chain of titles supporting your yellow line. His voice cooled. We'll provide what we're required to provide. Good. And if you interfere with established access, we'll seek immediate relief. Then file accurately. He hung up. The next morning, Patricia arrived alone. She stood at the gate with the orange stakes visible behind me. You could stop all of this with one signature. So could you. What does that mean? Withdraw the claim. Her expression sharpened. Stonegate has already spent money planning this expansion. There it was. Expansion. Not historic necessity. Not forgotten farm access. Expansion. That doesn't create an easement. You don't get to decide that. Correct. For the first time, she seemed surprised by my answer. That's what courts are for. She stared at me, then smiled. You think you can outlast us? No. I looked at the orange line cutting across the grass. I think paper lasts longer than confidence. That Friday, Laura called. They filed. I set down the wrench in my hand. Complaint and request for preliminary relief. Yes. Same exhibit. Same corridor. Same parcel number? Yes. And the affidavit? A pause. Attached. That was the point where Stonegate made the decision for us. A demand letter can posture. A negotiation can exaggerate. But once someone asks a court to rely on a document, every question around that document becomes part of the record. Who created it? Who reviewed it? Who noticed inconsistencies? Who knew what and when? Before anything else happened, I made the disclosures required because of my judicial position. I owned the farm. I had a personal financial interest in the case. I would exercise no judicial role in it. No calls to another judge. No courthouse staff working on my private dispute. No shortcuts. The case was assigned through ordinary process to Judge Eleanor Reeves in another division. In that courtroom, I would be Daniel Whitaker, landowner. Laura would be my lawyer. Judge Reeves would decide what the evidence supported. My Robe would stay out of it. 6 weeks later, discovery had turned Stonegate's confidence into a timeline. Laura and I sat in her conference room with 2 laptops, banker boxes, and printed emails spread across a table. She slid one page toward me. Read the date. 9 months before the SUVs came to my farm. Stonegate's survey consultant had emailed Patricia and Richard asking them to verify the legal description of the Eastern Corridor before representing it as an established easement. Patricia's response was short. Expansion scheduling cannot wait for another title review. Use the existing access documentation. Laura handed me another email. Andrew Pike to Richard. Parcel reference appears inconsistent with proposed corridor. Recommend confirming before filing or presenting as recorded access. I looked at her. He noticed. Yes. What did Richard say? She rotated the laptop. We'll address if challenged. I leaned back. 5 words. 5 very expensive words. Then came the affidavit metadata. The electronic file had not existed for decades. It had been created recently. The signature image had apparently been imported from an unrelated Whitaker document. We still did not know who had inserted it. Laura refused to accuse anyone before the evidence established the chain. That restraint made the facts stronger, not weaker. Stonegate's board minutes added another layer. Patricia had told directors that council had confirmed long-standing access rights before expansion spending accelerated. But Richard's internal correspondence did not say that. It said verification remained unresolved. By late afternoon, Laura had covered one wall with a chronology. Survey consultant warning. Andrew's warning. Expansion deadline. Unverified exhibit. Pressure campaign. My refusal. Filing. Affidavit. The case had stopped being only about whether Stonegate possessed an easement. Now it was also about who had been warned that the claim might be unsupported and who decided to proceed anyway. That evening, Andrew called me. His voice sounded different without Richard or Patricia beside him. Mr. Whitaker, I need to clarify something about the affidavit. Call Laura. I already did. That got my attention. I did not prepare it, he said, and I objected to using it until its origin was verified. Then make sure the record says that. A long pause. I intend to. He hung up. The next morning, Laura told me Andrew had retained separate counsel and was preserving additional internal correspondence. Stonegate's 3-lawyer wall had developed its first crack. 2 days later, Richard, Kevin, and Andrew were scheduled to appear at the courthouse on an unrelated commercial matter. So was I? The night before, Madeline found me in the barn. You know they still don't know. I assume not. You're really going to walk into that courtroom without saying anything first? Their case tomorrow has nothing to do with my farm. That isn't what I asked. I smiled. No reason to turn a professional obligation into theater. She shook her head. Dad, it's already theater. You're just pretending not to enjoy the timing. Maybe she was right. At 8:58 the next morning, the bailiff called the room to order. All rise. I entered courtroom 4 through the side door. Black robe, case file in hand. The room stood. Richard saw me last. Andrew recognized me first. His eyes widened. Kevin followed his stare toward the bench. The color drained from his face. Richard looked up, froze for half a second, then recovered. For 6 weeks, he had spoken to me like an aging farmer who had wandered into a legal argument beyond his education. Now he was looking at the same man from the tractor. Only the muddy boots were gone. I took my seat. Good morning. Please be seated. That was all. No smile. No comment about Stonegate. No reference to the farm. The matter before me was an unrelated commercial dispute that had been assigned to my docket long before Patricia drove onto my property. For the next 40 minutes, I listened to counsel, asked questions about the record, ruled on procedural issues, and did my job. Richard was professional. Kevin was careful. Andrew barely touched his notes. During recess, my clerk looked at me. You know those attorneys? I've met them. One of them looks ill. Courthouses affect people differently. I poured coffee. By lunchtime, Laura called. I just received an email from Richard. Let me guess. He'd suddenly like to discuss settlement. Very suddenly. I looked at the robe hanging behind my office door. Tell him my occupation changes nothing about the deed. When I later came through the public hallway without the robe, Patricia was waiting. She had apparently been attending the unrelated hearing on behalf of a Stonegate-connected business. Her face was tight. You're a judge. I am. You never told us. You never asked. Richard stepped in before the conversation could become theatrical. Judge Whitaker, regarding the pending Stonegate matter, we understand it is assigned to Judge Reeves. Yes. And you made the necessary disclosures? Immediately. You'll have no judicial involvement? None. His shoulders eased. He understood the line Patricia did not. She stared at me. You let us threaten you with court without telling us you sit on the bench. My occupation was irrelevant to whether Stonegate owns an easement. Relevant to how we were dealing with you. That sentence hung between us. Richard looked at her. Andrew looked down. Patricia seemed to realize what she had admitted. I waited, then said, You had the same obligation to verify your claim whether I was a judge, a farmer, or the man repairing your fence. Nobody answered. The next morning, I did not enter Judge Reeves's courtroom through a secured hallway. I entered through the public doors. No robe. No bench. Dark suit. Legal pad. Laura beside me. Stonegate sat across the aisle. Judge Reeves entered. Everyone stood, including me. Madeline was seated behind us. Before the hearing began, she leaned forward and whispered, Still think the robe is the interesting part? I looked at Laura's exhibit binders. No, the robe had surprised them. The documents were about to matter. Laura began with the deed. Then Dad's 1979 survey. Then the independent survey. On the courtroom display, Stonegate's recorded service lane easement appeared beside the corridor they wanted across Whitaker Farm. 2 different locations. 2 different legal descriptions. 2 different parcel references. Judge Reeves looked at Richard. Counsel, where is the recorded instrument establishing the corridor your client seeks to enforce? Richard stood. Your Honor, Stonegate's position is not confined to an express recorded easement. Historical use, development patterns, necessity, and equitable considerations. I understand the theories. I'm asking about this corridor. Silence. Laura did not smile. She moved to the boundary monuments. Dad's iron pin. The southern monument. The measurements. Then she displayed the disputed affidavit. My name sat beneath the acknowledgement. Daniel R. Whitaker. She did not call it forged. She did not need to. She established that I had not signed it. She established that my middle initial was not R. Then she introduced the metadata showing the electronic file was recent. The source document containing the signature image. Andrew's email asking whether the affidavit had been verified before use. Judge Reeves turned to Richard. Was it verified? He stood slowly. Not conclusively, Your Honor. Yet it was attached to your filing as support? A longer pause. Yes. Patricia leaned toward Kevin and whispered something sharp. Judge Reeves noticed. So far, she said. The court sees substantial unresolved problems with the claimed corridor and with the materials offered in support of it. That was what facts sounded like when nobody decorated them. Laura moved to the internal correspondence. The consultant's warning. Andrew's parcel number warning. Richard's response. We'll address if challenged. Then Patricia's instruction to proceed because expansion scheduling could not wait for another title review. Patricia's face changed when her own words appeared on the screen. Richard argued that internal caution did not prove Stonegate's legal theories were invalid. Laura agreed. That surprised him. Correct, Your Honor. The emails do not decide the title question. They establish that the claimed corridor required verification before Stonegate represented it as settled. Judge Reeves nodded. An appropriately limited use. That was Laura. Never make evidence carry more weight than it can hold. It did not need help. During recess, Patricia cornered Richard near the hallway windows. You told us this was defensible. Richard kept his voice low. You represented that the access documentation had been confirmed. I relied on counsel. Andrew passed them with his separate attorney. He stopped. No, he said quietly. You were warned. Then he kept walking. By afternoon, Judge Reeves denied Stonegate's request for preliminary relief. Stonegate had not established the basis necessary to force or construct the proposed corridor while the case proceeded. The disputed area would remain untouched. The orange stakes could stay. Nothing else could. Questions concerning the affidavit and representations made in the filing would be handled through appropriate independent procedures. No dramatic gavel. No applause. No instant declaration that Patricia had lost everything. Just a ruling. The kind that matters because it says exactly what the evidence supports and no more. Outside the courthouse, Patricia caught up with me. You knew this would happen. No. You're a judge. Not in that room. She stared at me. I held up the copy of Dad's survey. This existed before either of us. Richard approached behind her. He looked tired. We'll advise the board regarding next steps. Laura closed her case file. That would be appropriate. Within days, Stonegate's board held an emergency meeting. The minutes came to us through the case. Directors wanted to know why expansion spending had accelerated while the title issue remained unresolved. They wanted to know why letters described a corridor as established when nobody could identify a matching recorded grant. They wanted to know why the wrong parcel number remained on multiple exhibits after counsel had raised concerns. And eventually, they wanted to know why an affidavit carrying my supposed signature had entered the file without verified provenance. Patricia survived the first meeting, not the second. The board suspended her authority over the expansion project pending an independent review. 2 weeks later, Stonegate proposed dismissing the corridor claim as part of a broader resolution. Laura made them write everything precisely. The independent survey would control the boundary. Stonegate would claim no existing easement across the eastern field. No road. No utility trench. No construction traffic. The expansion would be redesigned through land Stonegate or its developer actually controlled. I accepted nothing until every line had been reviewed. 3 months later, the last orange stake came out of the pasture. Madeline and I stood beside the fence while a contractor pulled them one by one and threw them into the back of a truck. Metal clattered against metal. The boundary never moved, she said. No, people just got ambitious around it. Stonegate's independent review ended soon afterward. Patricia resigned as HOA president before the board held a final removal vote. The review concluded that she had pushed the expansion forward despite unresolved title questions and had represented the access issue to directors with more certainty than the underlying record supported. Richard's firm withdrew from representing Stonegate. Issues surrounding the affidavit went through separate professional and legal review channels. I did not interfere. I did not call anyone. I did not ask for favors. That was important. Justice stops being justice when you need special rules to obtain it. Andrew sent Laura one final letter confirming the chronology of his warnings. I never spoke with him again. He had been part of a team that pushed too far. He had also eventually decided that protecting the record mattered more than protecting someone else's confidence. I could respect that much. One Friday evening, I came home from court and parked beside the equipment barn. My robe was folded across the back seat. My work boots were behind the driver's seat. Madeline was waiting by the eastern fence. Walk with me. We followed the old property line while the setting sun turned the hay field copper. No orange flags. No survey trucks. No black SUVs. Just wind moving through grass and the distant rumble of machinery on Stonegate's redesigned route farther north. When we reached Dad's iron pin, Madeline stopped. Rust covered most of the cap. It was not impressive. Nobody would photograph it for a courthouse brochure. But it had survived decades of weather, developers, lawyers, expansion plans, and people who confused urgency with ownership. Madeline nudged the dirt beside it with her boot. They really thought the Robe was the scary part. I smiled. No. She looked at me. The scary part was that the deed never changed. A week later, Stonegate sent the final redesigned access map. Their road curved north and stopped well before our property line. I placed the map inside Dad's old steel cabinet beside the 1979 survey. Then I lifted the stubborn door, turned the key, and locked it. The following spring, I was repairing the same fence where Patricia had once offered to buy the corridor when an older Stonegate resident walked over. Baseball cap, work gloves, friendly expression. Judge Whitaker. Dan's fine out here. He looked across the pasture. I heard Patricia brought 3 lawyers to take this land. She brought 3 lawyers. And they didn't know you were a judge? Apparently not. He laughed. Bet you enjoyed seeing their faces. I thought about courtroom 4. Andrew recognizing me first. Kevin going pale. Richard realizing the farmer he had lectured about property law wore a robe for a living. For one moment, yes, I had enjoyed it. But that was never why I kept my farm. I looked toward Dad's iron pin. Knowing the law doesn't make the facts belong to you. The man nodded slowly. Then he walked home. I finished repairing the fence before dark. Staple, hammer, wire. Simple things. Permanent things, if you respect where they belong. Then I climbed onto the tractor and drove along the eastern field. The tires passed near the boundary. Exactly where the deed said it was. Exactly where Dad's survey showed it. Exactly where it had always been. Patricia thought 3 lawyers could turn pressure into ownership. The lawyers thought enough paper could turn an assumption into a right. All 4 mistook silence for fear. They were wrong. The Robe only revealed who I was. The record revealed who was right. And in the end, justice did not need to shout. It only needed someone patient enough to make them prove what they had claimed.